All right, this is case number 16-108289. This is case Credit Union versus Shanice looks like Motley. The matter is before the court on a petition for installment payments. Looks like there is also, I thought I saw an objection to a writ of garnishment, but I don't. All right, your appearance regarding this matter. I have someone for case Credit Union. All right, court calls. Moving on, the court calls case number 211-67480. This is American Express National Bank versus Barber case. The matter is before the court set on for a status conference. Your appearance for American Express National Bank, please.
Good morning, Your Honor. John Whitty, P66880.
Right, thank you, Mr. Whitty. Good morning to you. I'm looking now for Barber case, please. If you're on the Zoom, please say something at this time.
Good morning, Judge.
All right, good morning, Ms. Case. I see that you have filed, looks like you filed something in the nature of an answer. What I do see is a note to whom it may concern, and you provide some explanations regarding the issue of delinquency that is raised in this case. Is that correct, ma'am?
Yes.
All right, have you had, Counsel, have you had an opportunity to have any discussion with Ms. Case regarding this matter, sir?
Yes, Your Honor. We talked this morning. She's working with a third-party debt management company. So we talked about various options. I think we're really looking for time to hopefully be able to work something out. So we discussed 60 days discovery, Your Honor, and we're going to keep in contact and try to work something out.
All right, Ms. Case, anything you wanted to say before I set up some type of scheduling order on this case, ma'am?
No, sir.
All right, so what I will do is I will allow for the requested 60-day discovery period. That allows the parties to exchange information between each other, and it formally allows for information to be shared. I am going to set a date 60 days hence for you to return into the Zoom. Now, the discovery will be allowed through that day. Also, I will allow the parties respectively on either side to file with the court a motion or a petition that you wish, if there's something you wish the court to do or to consider. You'll have the opportunity to file that motion and set it for hearing on a date that I'm going to give you. June
14th.
the 14th, 2022. And that's going to be at 9:30 a.m. 2022 at 9:30 a.m. That's when you're coming back into the Zoom. The discovery is open through June 14th. You also, if you want to file a motion, a petition asking the court to do something, you can set it for hearing on June the 14th. The only requirement is that you make sure that the other side has at least 10 days to respond to any motion that you might file. That motion can be dispositive, or it can be a motion for some event within the context of this case, some petition that you wish the court to consider. As long as you file it and set it for hearing on the 14th of June, and you've given at least 10 days notice to the other side to respond, the court will hear it on the 14th of June. You're going to get a written document from me in the mail with the information I just shared with you contained in that document. It will also have a date that is June the 14th at 9:30 a.m. as your next action date of this matter. I do wish the two of you well. Good day to you.
All right. Thank you, Judge. Thank you, Ms. Case.
Thank you.
The court now calls case number 17-103-087. This is Specs Howard School of Broadcast versus Trey Terrell Cup. The matter is before the court set on for a status conference. The court looks like a writ of garnishment was filed regarding this matter. Your appearance for Specs Howard, please. Specs Howard. Do I have someone for Trey Cup on this Zoom? Pass on that matter. The court now calls case number 21-151422. This is Enhanced Center International Strike That Interventional Spine versus Allstate Insurance Company. The matter is before the court, set on for a review on today's date. Looks like the case was previously set up for a case evaluation. Your appearance for enhanced, please.
Good morning, Your Honor. Richard Brewer, P. 31124 on behalf of Enhance.
All right, thank
Good
you.
morning, Your Honor. Brandy Anderson appearing on behalf of Allstate.
You cross it over a little bit. Thank you. Good morning, Mr. Brewer. Your appearance at this time for Allstate, if you will, please.
Good morning, Your Honor. Brandy Anderson appearing on behalf of Allstate. Sorry about that.
All right, that's okay, Ms. Anderson. And what's your P number again for the record?
70876.
All right, thank you, and good morning to you, ma'am.
Good
All right,
morning.
So somebody update me. The last note I had was back, back in December, and I think I sent out an order for case evaluation. So somebody update me on this.
Sure, Judge. We did go to case evaluation. The acceptance and rejection period expires, I believe, the 26th of this month.
All right, and Ms. Anderson?
Yes, that's correct. We did. We went and we're still in that period.
Still in that period. All right. So I bring you back early in May. I should know something a little bit more by then.
Yeah.
All right. So let's see if I can get you back here in the month of May, and let's do a review at that time.
May 10th?
May 10th, that's 5/10/22. And that's going to be at 9:30 a.m. 5/10/22 at 9:30 a.m. Hoping that you're able to get it all worked out. Now we'll take a look at things at that time and see what direction the court can give you in this regard.
Very good.
Thank you, Your Honor.
Have a good day.
Good day to you as well, sir. Do I have department stores, counsel for department stores on this matter?
Good morning, Your Honor. Yes, Sam Cermak on behalf of Department Stores National Bank.
Just checking for a moment. Let me see if I also, it looks like I have a smart. So I know this is set for 10. I'm going to go ahead and call it now. Oh, yeah, well, we just skipped in. All right, this is case number 21-160501. This is Department Stores National Bank versus Renee M. Smart. And Madam Counsel, again, if you will, your appearance for Department Stores National.
Sam Cermak on behalf of Department Stores National Bank.
And your P number, if you will, for the record.
P85146.
Thank you, Madam Counsel. Good morning to you. I'm looking for Renee Smart on the Zoom. Looks like someone was.
I'm here. Can you hear me?
I hear you, Ms. Smart. Good morning.
Okay. Good morning.
All right. So it looks like this. I set it up for a scheduling conference. It looks like to me that there was a previous hearing date on the 1st of March regarding the status conference. But I don't see much action that's taken place on this. I do see that service was had by alternate means. Madam Counsel, have you spoken with Ms. Smart regarding this matter at all?
No, Your Honor, it was my understanding that she was working with a debt settlement company, but we have not heard from that debt settlement company.
All right, Ms. Smart, what's going on from your perspective regarding this matter, ma'am?
Yes, I'm working with Net Debt, and when I spoke with them, they told me that the negotiation that they because I gave them last time, I gave them the information to give them a call, and they said that they wanted to hear from me if I was able to increase the amount of payment to pay them, and I said I was unable to do that at this time. So to just petition the court again to ask for more time, because I did enter like 5 credit cards. So Macy's is the only one that has brought me to court. So it's not a matter of not trying to pay them. It's just a matter of asking for more time. So that was what I was told to mention, to appeal to the court in terms of making the payment, because I am paying them. And it was when I signed up with the couple years ago, I've been in it for over a year. It was my understanding that as long as I was in this program, I wouldn't have an issue, that if they were aware, any of the creditors were aware that I'm in this program, that they would be able to work with them. So this is where I am now. Like I said, Macy's is the only one. So I just appeal in the court to for more time. I am in the last, there's one creditor right now is being paid off, and they did send me an email with all my other things paid off, and then Macy's would be next. So that's my appeal to the court and a conversation that I had with them. Thank you.
All right. So, I mean, you know, I think that generally creditors are willing to work with third-party agencies. That's not something really that the court gets involved with. But usually if there's something that's working, then the court will allow the parties to engage in that process. This case has been going on, it seems like since, I'm looking at since September of last year. So
Okay, I'm not aware of anything prior to when I had to come to court, because what it is, they asked me if I was willing to add more money, and I told them I was unable to add more. I don't have any extra money to give
Yeah,
to pay
let me stop.
towards that
Let me
debt.
stop you. Let me stop you. Already
Oh,
told
I'm
me that.
sorry. I'm sorry.
The issue here is, well, let me ask you this. It doesn't appear to me that you're disputing the debt in this case.
Judge, I can hardly hear you. I'm sorry. Say that again.
Yeah, it does not appear to me that you're disputing this $2,500 debt in this case.
No,
You're not-
no,
All right, so
no.
you're looking for a way to try and have an organized strategy to pay it, correct?
That's it. That's it. And I was in hopes that that I just have the time to do it, because I'm so close to coming out of debt. So that was the only thing that I'm just appealing towards, is just that they be able to work in a time frame that net debt could that I could give them more money. So that's it.
All right, Madam Councilman Stern.
I'm sorry. Say that again.
Talking to the attorney, Ms. Sherman, I'm sorry.
Okay.
There's something sound today, ma'am. Were you able to hear all of that exchange, Ms. Sherman?
Yes, Your Honor, I was.
So what are your thoughts in this regard? I guess one of the central questions is probably how soon is Ms. Smart able to move forward? Because there's not really a dispute on this debt, and that's the challenging, where it's not really a dispute. The plaintiff would likely be entitled to a judgment on this case because it's not really a disputed debt. And if you could come up with an amount to pay, or if a 60-day delay in enforcement of the judgment is something that would help you, that can probably be arranged. But right now, everything is held in place when the plaintiff, it looks like they may very well be entitled to judgment because there's not really a defense to the claim. Ms. Shermack, go right ahead if there's something you want to say, and then I'll come back to you, Ms. Smart.
Sure, Your Honor. I think at this point, it might be best to go ahead and proceed with the scheduling order. Like I said, we would be more than happy to work with net debt. We just have not heard from them at all in terms of timeline or anything like that.
Can I just inject? Now that is what was explained to me is that they didn't want to appeal to you guys because unless I was able at this moment to increase my payment. So if you're willing to work on a time frame, I would be happy. So I don't mind paying, but that is why they explained to me they didn't even want to come to you without the offer, because based on the negotiations, I would have to increase I think they said my monthly payment by more than what I can afford at this time.
Yeah, you don't
So
have
I
to
just asking for more time. That's all. Thank you.
Yeah, you don't have to tell all the details of it. The ideal here is that, of course, if they're going to talk with someone at department stores, they would have to, I mean, the ideal here is how are you gonna pay it? That's kind of the challenge here.
Yes,
So,
yes, sir.
So, Ms. Cermak, you favor the court setting it on a scheduling order rather than trying to move towards entry of some type of order at this time based upon the undisputed debt.
Yes, that's correct.
All right.
Thank
All right,
you.
so what I'm gonna do is I will go ahead and set it, put a scheduling order on it with a return date of June 14th. That's 6/14/22, and that's gonna be at 9:45 a.m. 6/14/22. Discovery will be open through that period of time. And also the court will allow for the parties to file motions dispositive or otherwise and set any such motions for hearing on the 14th of June of 2022. And the court will hear the motion on that date, so long as at least 10 days notice has been given to the opposing party. You can file your motion dispositive or non-dispositive. I'll hear it on the 14th of June, as long as you give 10 days notice of the motion to the opposing party. This does not prevent the filing of motions beyond that date, but this is a convenience that's allowed in the event that the issues are narrow enough that the party wishes to file a motion. All right, so you'll get an order from me, both sides, setting the new date for the 14th of June 2022 at 9:45 a.m. And they will allow for discovery through that period of time. I do wish you well. Good day to both sides. All the best.
Oh,
Thank you.
okay, so let me, before I hang up, I just want to get an understanding that as long as net debt contacts them, because I'm just, where am I? In terms of coming back on the 14th, is this something that should be scheduled? I'm not sure where I stand.
Well, what the first thing I want you to understand is that coming to court and responding to a court direction is more significant than anything with net debt. That's the second thing. You got to come back to court on that date.
Absolutely.
And this order allows for the parties to request information, for the parties to send interrogatories, a set of questions, requests to admit, documents that can be sent out asking for you to respond to questions, or you asking the plaintiff to respond to questions on both sides. That can be done over the next period leading up to the 14th of June. Also, either party can file a petition with the court asking the court to do something. That's called a motion. It's called a petition sometimes. To petition the court to do something and set the hearing for the court to listen to your motion on the 14th of June. And all you have to do is make sure that you send that motion out early enough for the other party to have 10 days to respond to it, and then I'll hear the motion. As it relates to the third party or the third party entity that's helping you, they will be, you should be in touch with them, and they will want to be in touch with Ms. Cermak to see if something can be worked out. But even if something is not worked out, you're still going to be back here for the hearing on the 14th of June, 2022. All right, I wish you well.
Oh, yeah, absolutely. Okay, thank you. Thank you. I was just making sure I had a little more time. Thank you so much. And thank you, Ms. Cormack. Thank you so much.
Thank you. Good day to you, ma'am. All right, the court.
Thank you. Mhm.
All right, thank you. The court is calling again under 17-103-087. That's Specs Howard School of Broadcast versus Terrell Trade Cuff. This is regarding a writ of garnishment, and the court set it on for a hearing on today's date. Do I have anyone on this Zoom related or connected to that particular case? This is the second call. The matter was set for 9:45 a.m. It does not appear that either party has appeared on that matter, and accordingly, the objections to the writ of garnishment in this matter would in fact be denied. The court also at this time is recalling the case number 16-108289, case credit union versus Shanice Maxey, it appears, MATSEY. That matter appears to be a motion for installment payments that got set on for hearing. And there's also connected to that a subpoena, the issuance of a subpoena for the defendant to appear on today's date. It appears that neither party has appeared regarding these matters. Therefore, the subpoena in this matter will be dismissed. That's the matter that's principally before the court. The subpoena will be dismissed where neither party appeared regarding that matter. And that is the order of the court in those two matters. Right? Just one moment. What is it?
Coleman.
Okay. All right. Thank you, court reporter. It looks like we covered what we need to cover.